I'm Kim Mutcherson, co-dean of Rutgers Law School in Camden, and I'm here to offer a very unusual episode update. The podcast episode you're about to hear involves an interview with Professor Meliss Murray, who is the Frederick I and Grace Stokes Professor of Law and Faculty Director of the Birnbaum Women's Leadership Network at NYU Law School. In this episode, among other topics, we discuss SB 8, the controversial Texas law that essentially bans abortion for most people in the state. Since Professor Murray and I spoke, the moving pieces of litigation challenging SB 8 have continued to shift. Most recently, on Friday, October 22nd, the Supreme Court granted a request by the Biden administration and a group of abortion providers in Texas to bypass proceedings in the Court of Appeals and bring two issues to the Supreme Court, which they set for oral argument on November 1st. In the case brought by the administration, the court will consider whether the federal government can sue in federal court to block enforcement of SB 8. In the case brought by the providers, the court will consider the problematic private enforcement structure created by the law, which deputizes citizens to police the medical procedures of their neighbors. Despite this expedited schedule to review these procedural issues, the court has failed to stay enforcement of the law, which has been wreaking havoc on the provision of abortions in Texas since it went into effect on September 1st. As she did when the court failed to stay this law when first asked to do so, Justice Sotomayor dissented from the court's most recent decision. This time, she was the only justice to do so. She wrote, quote, "There are women in Texas who became pregnant on or around the day that SB 8 took effect. As I write these words, some of those women do not know they are pregnant. When they find out, should they wish to exercise their constitutional right to seek abortion care, they will be unable to do so anywhere in their home state. Those with sufficient resources may spend thousands of dollars in multiple days anxiously seeking care from out-of-state providers so overwhelmed with Texas patients that they cannot adequately serve their own communities. Those without the ability to make this journey, whether due to lack of money or childcare or employment flexibility or the myriad other constraints that shape people's day-to-day lives, may be forced to carry to term against their wishes or resort to dangerous methods of self-help. None of this is seriously in dispute. These circumstances are exceptional. Women seeking abortion care in Texas are entitled to relief from this court now. Because of the court's failure to act today, that relief, if it comes, will be too late for many." End quote. To keep apprised of the continuing saga of SB 8, I urge you to follow the Strict Scrutiny podcast on Twitter and listen to their up-to-the-minute commentary on the ongoing litigation. I am deeply honored to have as my guest today Professor Meliss Murray from NYU's Law School, who many of you will also recognize from television and from her amazing podcast that she does with Kate Shaw and Leah Littman, Strict Scrutiny. So thank you so much for being here, Melissa.
Thank you for having me. It's great to be here with you. Reciprocity from when you came on our podcast. So this is cross-fertilization once again.
Exactly. Perfect. So I want to start with you the same way I start with everybody else who is kind enough to join us on the podcast, which is with your origin story. So given all of the things that you could have done with your life, you decided first to go to law school and then to become a legal academic. Can you trace that path for me?
I was born by the river in a little tent. So I'm the daughter of Jamaican immigrants. No one in my family had been to law school. No one was a lawyer. My mother was a nurse, and she was very clear-eyed about that. When she was growing up in the 1950s, the only option, certainly in Jamaica, for women, if they even got the opportunity to complete their high school education, was to be a teacher or a nurse. And so she picked being a nurse instead of being a teacher and wound up coming to the United States on a special visa because there was a shortage of nurses. But she was really adamant that I have the full range of possibilities open to me in the way that her mother, who had not completed high school and really could not read beyond the first grade level, was absolutely adamant that all 5 of her daughters complete high school and go on to have some kind of profession, even if it was bounded by the expectations of their society. But, my mother wanted me to have wide open vistas. I still remember in 1981 when Sandra Day O'Connor was appointed to the court, my mother telling me, girls can be lawyers and judges. I did not know I wanted to be a lawyer. I suspected that I wanted to be a lawyer because everyone in my hometown who was a person of consequence was either a doctor or a lawyer. And so I was like, I want to be a person of consequence at some point. So I thought maybe I'd be a lawyer, but I didn't know any lawyers until my father passed away when I was 17. And he passed away without a will. And so, my mother was sort of thrown into this maelstrom of intestacy and trying to figure out and sort out his estate without the benefit of a will. And so she relied on this probate lawyer to sort of get her through it. And he just had such command over everything. And our family was like falling apart. My mother was devastated by my father's death, and as was I. And, he was just this sort of calm in the center of all of it. And, I aspired to that kind of control. I mean, when you lose a parent that young, I think you aspire to a kind of control over your life anyway. But this was a guy who just sort of seemed to know what was going on and what was going to happen next. And more than anything, I wanted to know what was going to happen next. And so, I was like, yes, that's what I would like to do. And so I went to college, wound up going to law school, thought I was going to be a civil rights lawyer. I really wanted to work at the NAACP Legal Defense Fund. The problem, of course, is that I was funding law school independently. So I had to work at law firms during the summer while splitting my summer with these public interest outfits. And so that first summer, I worked for a very fancy New York law firm, which will go unnamed. But while I was there, I just had this epiphany. Like, I think I was called by someone else's name one time too many and asked to do something like collect coffee or bring things to other people one time too many. And I just went back to my office and slammed a book down on my desk and just decided right then and there, no one was going to tell me what to do in my job ever again. And there aren't a lot of jobs for new lawyers where no one is telling you what to do, or no one's not telling you what to do. And so I looked around and realized the people who were happiest with themselves, certainly at my law school, were the professors who, just really seemed to be the cat that got the cream. Like, they were having the best time. And I was like, no one is telling them what to do. And so I decided then and there, like, that is the life for me. And so a completely serendipitous route into the academy. And I think it's not unlike the route that many women of color academics have. Like, we don't plan on this. We don't go to law school with this in mind, but somehow we get there. And then the question is how to get through it, how to enter, how to keep going, how to get tenure, how to be successful, because there really aren't a lot of models for us. And there certainly weren't when I was a law student.
Yeah, absolutely. And I've had Mira Deo on the podcast, and Mira's just amazing, and the work that she's done in Unequal Profession has been really tremendous, and I think has really sort of opened lots of folks' eyes to women of color in the legal academy. And, like you, I am also an accidental law professor, very much an accidental dean, which is its own fancy story.
Same, also.
Yeah, it happens sometimes. But I'm curious for you, I think for a lot of us, there had to be a person or a couple of people who finally put us on that path to ending up in academia and sort of, made transparent things that were otherwise opaque. Was there someone, or were there a few people like that for you?
Sure. So this is a great opportunity. I've never actually said thank you to her in a public setting for this, but my second year of law school, Laura Kalman, who is not a law professor per se. She actually teaches at the University of California, Santa Barbara, and she's a legal historian. She came to Yale to visit for a term. And she was doing research on a book that she was writing about Yale in the 1960s and sort of like the academic debates that eventually spilled over from the law school into the general ether. And she put an announcement out. She needed a research assistant. And I was always hustling, looking, for ways to make money in law school. And so I was like, I could be her research assistant. That sounds great. So I remember being in corporations and like applying for this job in the middle of class. And she wrote back immediately, and we sort of struck up this friendship online. And, she hired me. I worked for her for that year, and it was amazing. I mean, she was just amazing. She was like no law professor I'd ever met. She was enormously encouraging. And over time, I came to confide in her, like, I think I want to be a law professor. And, when I told one of my other professors that I was thinking about academia, he told me, you have to be really smart to be a law professor, which I immediately took as not you.
Right.
Like, you're not
Wow.
smart enough to do this. And she never said anything like that. She's like, of course you're going to be a law professor. Like, why wouldn't you be a law professor? And was just so endlessly encouraging. And at every step of the way in trying to get into the academy, she was right there advocating for me. When I went to look for a fellowship, she was right there advocating, and she was enormous. The other person who also I think was so tremendous in terms of her mentorship was Justice Sonia Sotomayor and my other judge, Stephen Underhill in the District of Connecticut, who literally there was nothing I could ask for that was too over the top. They're like they had my back in every possible way and made sure I knew it. And then the last person, or persons rather, were Carol Sanger and Ariella Dubler at Columbia, where I was a fellow for 2 years. And, Ariella was just fantastic. She was still untenured herself, but she really shepherded me through the whole process, was a mentor and a reference for me. And when I think about she was doing this while she was trying to get tenure, it is just so extraordinary to me, the depth of that generosity. And she was fantastic. And so was Carol. And so, I really benefited from these women. And one thing I wanted to just underscore to your listeners is, I'm a Black woman. None of these women were Black women. And if I had waited to find mentors who looked like me, I would still be, in New Haven waiting. There was no one there when I was there who looked like me. And so I really had to find people with whom I had this kind of organic connection. And I actually think it made the relationship deeper and more productive on both sides, truly reciprocal, because we were drawn to each other because of shared interests as opposed to some sort of superficial identity. And this is not to slam looking for mentors who look like you, because I think it can be a very good way to begin the process. But it is to say, do not shut the door on those who don't necessarily share certain aspects of your identity, because they can be really terrific and effective mentors for you.
Absolutely. Absolutely. And it sounds a lot like, and I don't always draw this distinction, but I know other folks do. You need mentors, but you also need people who are your champions, right? So people who, when you're not in the room, they're still saying fantastic things about you and, creating opportunities for you.
Yeah, I think that's exactly right. It's the kind of mentorship that I aspire to perform for my students, for my mentees, to truly be not just a mentor, but like an advocate,
Yeah.
because that's what you need, especially for people who are on the outside
Yeah.
to some degree.
Yeah, absolutely. So I'm going to switch gears and move us into talking about the interesting legal landscape in which we're living, particularly for folks like you and me who do reproductive justice work. So before I start talking about Britney Spears and SB8 and all these other fun things, can you give folks a quick definition of what reproductive justice is? Because I think a lot of people hear that phrase and they think it's just another phrase that means reproductive rights.
Or more specifically, abortion.
Yes.
I think it's a very crabbed vision of both reproductive rights and reproductive justice to think of it exclusively as about the right to an abortion. I think that is part of it, part of both rubrics, but abortion does not exhaust either vision. So reproductive rights, I think, came into being as a concept in the 1970s, certainly with Roe, but also because of Griswold versus Connecticut and Eisenstadt versus Baird, which made clear that contraception was also something that was in the realm of individual choice. For a very long time, I think the mainstream reproductive rights movement really focused on the question of abortion and contraception because that's what the court had dealt with. And they did so in terms that were really dictated by the court's decision. So, this was a set of rights that was bounded by the logic of privacy because that's how the court had decided those cases. But it's really important to recognize that even before Roe, before Griswold, before Eisenstadt, people had been making claims for birth control, for abortion in registers that went beyond privacy. So, there's a case in New York, Abramovitz versus Lefkowitz, which is a challenge to New York's restrictive abortion law, where feminist lawyers are arguing against this law in terms that are about equality, and not just sex equality, about race equality. They talk about the women of color who are disproportionately impacted. They're making class claims, like it's poor women who are going to be shut out here. And so they are making all kinds of claims in both the Register of Privacy and the Register of Equal Protection. And eventually the case gets mooted because they are so successful in agitating that the New York legislature repeals the law and liberalizes abortion access in that state. So it never actually gets to the US Supreme Court. There's another challenge in Connecticut, Abele versus Markle, or Women versus Connecticut, which also makes similar claims in both the registers of privacy and equality. That winds up not going to the court. It's ultimately Roe that gets there. And Roe is argued in a more limited fashion, focusing on privacy, and the court decides it in a more limited fashion, building on Griswold and deciding that on the right to privacy. And that basically sets the tenor of reproductive rights advocacy for a generation. Like, they're arguing on the terms that the court has laid out. And so you lose a lot of those class equality, sex equality, the race equality arguments. And because you're not arguing those registers, there are a lot of women who fall out. And so for a long time, there was a complaint that the mainstream reproductive rights movement was inhospitable to the needs of women of color, to the needs of poor women, disabled women. And reproductive justice, I think, comes up to kind of pick up that mantle and to really interrogate, what does a vision of reproductive rights look like without these women who are marginalized? And so their goal is to integrate them. And I don't really think of it as a movement that comes up in the 1990s, because although that's when it is credited with coming up, but I just think it's picking up where these earlier movements left off. They were always there. They'd been seeded. They'd just been abandoned and allowed to go fallow. And so they're resurrected in the 1990s. And they're also resurrected alongside, I think, a more fulsome vision of what reproductive freedom looks like. And so on this account, they are again assailing the court, which has framed the logic of reproductive rights in negative terms, like restraint on the states from doing things to you, as opposed to positive entitlements to certain things. And so the reproductive justice movement is not just about integrating different voices, but providing a different vision of what it looks like to have reproductive freedom. It is not just about avoiding parenthood, but affirmatively choosing parenthood and being able to have children, to raise families in conditions of safety and economic security. And so, this is a movement that's about access to healthcare, access to safe neighborhoods, access to a range of different services. It is redistributivist in its ethic, I think, in a way that the reproductive rights movement, as originally conceived, wasn't. And so for that reason, I find the reproductive justice movement really exciting and interesting, and one that speaks to me in ways that I'm not sure the reproductive rights movement has always spoken. It's been very successful. And I think we are seeing now the integration of a lot of reproductive justice themes into the mainstream reproductive rights movement. I also think we're seeing the introduction and integration of reproductive justice themes into anti-choice movements as well, which is, I think, a really interesting, disappointing perhaps, but I think it speaks to the power of reproductive justice.
Could you talk about that a little bit more? What are the ways in which you see RJ seeping into anti-choice work?
So I think to the extent that reproductive rights framed the whole question as about access to abortion and about privacy, reproductive justice inserts in a more robust way this question of equality and along multiple dimensions: disability rights, sex equality, class equality, race equality. And they've been really successful in doing that. And I think those who are opposed to abortion rights and to contraception, for that matter, have seen how successful that integration has been. And so what we're seeing now is not simply an effort to justify restrictions on abortion and contraception in terms of women's health or the potentiality of life, but now in terms that sound in the register of racial justice. So I think it's really interesting, in the wake of last summer or the summer before, and the killing of George Floyd, there was a spate of anti-choice activism that argued, if you care about Black lives, if Black lives matter, then unborn Black lives should matter. And so it wasn't new. It had been sort of coming up and percolating for about 5 or 6 years. But this idea that reproductive rights is really laced and shot through with issues of racial injustice has become much more prominent and part of the discussion in anti-choice circles.
Absolutely. And I remember, I guess it was a few years ago where there was that billboard campaign where it was something like, the most
The most
dangerous
dangerous
place.
place for a Black child
Yeah.
is a home. Yeah.
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 Which is very striking to have taken that position.
I'm sorry. I mean, it is so selective,
Yes.
right? So, I mean, they are borrowing the interest in racial justice, but not marrying it to the other efforts on the reproductive justice line of thinking. So, yes, invoking racial injustice, but not then going further to say, like, well, why is it that there are disproportionate rates of abortion within Black communities? Is it because there are uneven employment prospects for Black women and Black men, the rife with employment discrimination in some contexts? Is it the lack of economic security, the concern about a lack of childcare, incredibly high rates of maternal mortality and infant mortality among these communities? Like, is that part of the story here, as opposed to simply what appears to be kind of just a naked kind of blaming of Black women for choosing to terminate a pregnancy? I mean, there are these background choices that shadow the whole question of choice.
Absolutely. I always, whenever I'm teaching, I teach a class called Bioethics Babies and Baby Making. And one of the points that I make to students consistently is, choice is always exercised within constraints. And in this country, those constraints are often tied to race and class and gender, and all these other sorts of categories that we like to pretend don't really matter. So I want to have, now that we have sort of, reproductive justice laid out in that really beautiful way from you, I want to talk about some of the things that have, I think, really brought reproductive justice to the fore, or at least potentially could have brought it to the fore over the last several months. And one of those pieces, really interestingly, was Britney Spears and this sudden revelation as part of her conservatorship that her father was able to make decisions about her birth control, including a decision that she would not be able to remove an IUD and therefore couldn't become pregnant. And there was this sort of, uproar in lots of circles at the idea that someone other than a woman herself would be able to make decisions about her contraception. And, my thought was, where have you all been? Right?
We've been here for a while.
Yeah.
So the Britney Spears episode, I think, is really important because it makes clear to people who have not had their eye on this ball that this is actually a very pernicious problem. It is one that affects the disabilities community disproportionately, the whole question of conservatorships. And it is not just a question of how someone with either mental or physical disabilities is cared for. It is about how they exercise certain aspects of their freedom, their autonomy. And it's just a very stark reminder that there are often incredible constraints placed on those with disabilities. I think what struck so many people about Britney Spears is that she's white, she's wealthy, she's famous, and therefore you would expect that she would avoid the kinds of things that I think often befall people who are suffering from mental disabilities or mental illness or physical incapacity in some regard. And so it's great that that could be a spark to catalyze a conversation, but I hope the conversation doesn't end there. And I hope the conversation is one that isn't just prospective about what to do about conservatorship going forward, but also retrospective and thinking about all of the ways in which reproductive policy and coerced sterilization is very much a part of our history. And one of the reasons why Britney Spears seems so unusual is because typically the women who have been singled out for coercive sterilization have been women of color. Fannie Lou Hamer famously discussed the circumstances at Sunflower County Hospital in Mississippi where she lived. Like, she went in to have a cyst removed, came out with a hysterectomy, right? Did not know, was not told, was performed without her consent. And she said almost every Black woman she knew who entered Sunflower County General Hospital left sterilized, right? the same time we're talking about Britney Spears, just a year ago, we had a whole spate of sterilizations of women who were in ICE custody. And that was talked about for maybe 2 days. And then Justice Ginsburg passed away. And ironically, we abandoned the story so
Yeah.
we could focus on the death of Justice Ginsburg, who, as a lawyer for the Women's Rights Project, was litigating challenges to coercive sterilization policies in the South, policies that made receipt of public assistance dependent on getting your teenage daughter sterilized, or the whole family would be off of public assistance. And she litigated those. And we literally, as the media, as a society, dropped the ball on those ICE sterilizations to talk about her legacy without ever understanding the irony of what we were doing.
And, one of the things that I think is, deeply reflective of the moment that we're living in is both how much history people don't know and how focused too many Americans are on forgetting the history that we do know, right? So, you talk about Fannie Lou Hamer, and I think about the phrase Mississippi appendectomies, right? Exactly what you were describing. You go into the hospital for something and then you end up being sterilized and they don't even tell you that this has happened. And, we have story after story like that. And it really reflects part of what's important about reproductive justice, which is it's not just about not having babies, right?
Yeah.
It's about how many women in this country over a series of centuries, frankly, have been told you don't deserve to have babies, right? Whether it was white supremacy or, discrimination against people with disabilities, right? This whole sort of series of ways in which this country has controlled reproduction for certain populations for a really, really long time.
Well, and it's not just the policies that are explicitly about reproduction, like the coercive sterilization policies that were endemic during the 1960s through public assistance, but also were very much a feature of the eugenics movement. Justice Thomas wants to talk about abortion and eugenics, but really what we should be talking about is eugenics and forced sterilization, because that really is the reproductive policy that eugenicists really were focused on. But all of these things, we need to look at them across the whole suite of interventions that are happening. And it's not simply that we are missing just the history of what's going on. I mean, we're missing sort of the cultural and the community-minded aspects of this. And I'm thinking of Madrigal versus Quilligan, which is another case that is never taught because it isn't actually in the Federal Reporter. You actually have to go and find the decision because it's not actually reported at all. But that was a case involving 10 Central American and Mexican migrants to the United States who went in to a Los Angeles public hospital to deliver their babies. They were pregnant and they don't speak English, and they are basically asked to sign these papers or to indicate their assent to what is essentially a procedure to tie their tubes after their children are delivered. And the decision talks about, is this informed consent? Is it not? What makes it coercive? What makes it not coercive? Have they brought this case properly before the federal court? There's very little discussion about how in this community, having children is a way in which women are understood as women. Right? This is a big part of what it means to be a woman, this identity as a mother. And in having that stripped from you without your consent, it's a massive imposition and indeed a betrayal. By the same token, you might also think about this whole idea that the state could impose upon individuals through abortion restrictions the identity of mother as sort of working the other way. And so these are really complicated questions about autonomy and liberty. And at the heart of all of it is, where is the state? Who is making the decision? And in Justice Thomas's concurrence in Box, which I've written about endlessly, in which he's trying to graph the history of abortion to the history of eugenics, what is missing from his attempt is a lot of other history that he overlooks, but also this idea that there is something fundamentally different about a state policy of coercive reproduction and coercive sterilization, and the prospect of a woman of color of her own volition making decisions based on her circumstances about whether or not to have a child.
So on one hand, we've been having this conversation about, birth control and conservatorship and, all of this. And then coming after that was Texas's entry into
Texas said, hold my beer.
Right. We've got something for you. So I know that you've been talking a lot about SB8. I've been talking a lot about SB8, but for those people who somehow have avoided understanding what is going on in Texas and then what the Supreme Court did in response, failed to do in response to what's going on in Texas. Can you just explain SB8 for people and also why it is different from other abortion statutes that have been challenged?
So let me lay the scene a little bit. Ever since 2016 and the change in presidential administration, there, I think, has been increased activity among anti-choice activists and an accelerated legislative agenda because they recognize that with the new president will come new judges at the lower federal courts and at the Supreme Court. And they're right. President Trump manages to stock the lower federal courts with conservative nominees. He has managed to put 3 nominees on the U.S. Supreme Court. And he was very clear. He was going to appoint individuals who would overturn Roe versus Wade. So those with a demonstrated antipathy or at least skepticism of reproductive rights. So that lays the scene. And in response, I think you see state legislatures just really pushing the envelope, doing the most, going further and further than they ever have before. And typically what happens when they push the envelope, pass a law, for example, like the one Alabama passed, which was a heartbeat law that limited abortion to some period of time. I think it was 12 weeks or 10 weeks. It was immediately enjoined. It was immediately challenged by reproductive providers and then immediately enjoined because under the court's existing precedents, Roe and Casey, the state cannot proscribe abortion entirely before viability, which is generally at the 23, 24 weeks marker of pregnancy. And so these laws would get passed and they'd really just be symbolic, like sort of like the pro-life movement flexing its muscles because they were never permitted to go into effect because they were patently unconstitutional. But here's the rub. Having the law go into effect is actually what they want because if the law can go into effect, these heartbeat laws, it's going to obviously restrict access. And if access is restricted, then some providers are not going to be able to stay in business. And if providers go out of business, even if the law is later declared unconstitutional, they're not going to come back online. And we saw this in Texas in 2016 when the court in Texas allowed an admitting privileges law to go into effect while its constitutionality was being litigated. The Supreme Court later invalidated that admitting privileges law in Whole Women's Health versus Hellerstedt. But in the time being, between when the law went into effect and when it was declared unconstitutional, Texas went from having 40 abortion providers in the state to having 19. Right? And they did not all come back online afterwards. So getting the law on the ground, shutting down providers, that's the name of the game. That's what they want to have happen. But they're always thwarted with these patently unconstitutional laws like these heartbeat bills because they're always enjoined. Right? So how do you get the federal courts out of this so that they can't enjoin these laws before they go into effect? Well, this is the devilish thing that Texas has done. Typically, when you pass one of these laws, the person who enforces it is going to be a state official, the district attorney, the person who heads the Department of Public Health. Here, however, though, there's no one charged with enforcing this law. And that's the thing that makes this law both kind of insanely devilish, but also really pernicious for reproductive rights providers. Because there's no state actor enforcing the law, there's no one to sue to enjoin the law's execution, right? So what Texas did was instead of having the state enforce this law, it delegated enforcement of the law to private individuals through this bounty system. So you, random barista at Starbucks, if you find out that someone has performed an abortion or helped someone, aided and abetted someone to perform an abortion or to get an abortion, then you can seek and you have a cause of action to file a lawsuit against the provider against the person who helped, and to bring that case to the courts and to sue them for violating this law. And if you win, you get $10,000 and your attorney's fees. And it doesn't run the other way. If the provider wins, if they manage to beat the charge, they don't get anything. So it is meant to incentivize individuals to bring these lawsuits and thus to chill providers from performing this. But more importantly, it's meant as an end run around federal court review, which would make these laws get enjoined before they could even go into effect. And so that's what you had here. Texas passed this law. Immediately, the providers tried to sue they couldn't sue any state officials who are enforcing it. So instead, they sued Texas judges, Texas clerks, and pro-life groups on the ground that these are the people who will have to facilitate these lawsuits as they go through the system. And there's supposed to be a hearing on that at the federal district court level. There was a hearing on the question of whether these state actors, because they are processing suits, were immune because it's just part of their job. The district court made a decision on the immunity. It was immediately appealed to the Fifth Circuit. They haven't ever had the hearing yet on whether to enjoin the law entirely. They get to the Fifth Circuit on this question of immunity. The Fifth Circuit, in this very unorthodox move, says, we're just going to stop all proceedings in this case right now. So they put a stay on everything in the district court on this law, which just basically grinds everything to a standstill. So the providers then appeal to the circuit justice for the Fifth Circuit, who is Samuel Alito. Justice Alito refers the case to the entire court. The law is going to go into effect on September 1st at midnight. And so this is now, I think, August 30th, this is all happening, so days away. And the court is taking this up ostensibly, and we're all waiting, and we're all waiting, and we're all waiting. And suddenly it's 11:59 on August 31st, and suddenly it's 12 midnight on September 1st, and the Supreme Court has said nothing. And so the law goes into effect, and abortion providers stop providing abortions in Texas. The pro-life groups celebrate that abortion is ended in Texas, and we're still waiting for the court. Yeah. And then finally, on September 1st, at around, I think it was 11 o'clock at night, the Supreme Court weighs in and says that because of the procedural irregularities surrounding this law, and they're specifically noting the odd enforcement structure of it, they're not in a position to enjoin this law. They're just going to let it go into effect. And they're very clear, like, we're not saying anything about whether the law would be constitutional or not, because everyone knows the law is unconstitutional. Right. But they nonetheless sideline almost 5 decades worth of precedent to allow Texas to have this law go into effect, to basically curtail and hobble abortion rights in the second most populous state in the union. And they say it's a procedural thing. And all of the conservative commentators say, oh, it's a procedural nothing burger. Of course the court would do this. It's a procedural thing. When everyone knows that procedure has substantive implications. And the substance of this is that the court ignored the substance, let a law that was crafted to defy existing court precedents go into effect, and they said nothing.
Yeah, we're both Twitter people, and I remember in the days leading up to this that there were a number of folks who just said, there's no way that the court is going to let this go into effect. I mean, they're gonna stop it. And they didn't, right? And so I think there's sort of two issues that come out of that. One, obviously, is what does this mean for abortion rights in this country, particularly because we know that the court has Dobbs on the docket for this year. The oral argument, I guess, is going to be in December. So we'll expect an opinion in June. And I think that, what happened here suggests what that opinion will say about Roe versus Wade. So that it's the abortion issue, obviously, is one part of it. But I think there's also this larger question about our trust or faith, to the extent that we had any, in the U.S. Supreme Court.
So let me address the question of Roe. The fact that this case, Dobbs versus Jackson Women's Health Organization, was already pending, and the court was slated to take up this case in the newest term, October term 2021, would have provided the court with a perfectly plausible way to enjoin the statute and say, we're just going to wait until we decide Dobbs, and Dobbs will likely resolve some aspect of this. And they could have done that. They're the Supreme Court. They can do whatever they like on that ground. The fact that they didn't, I think, is a harbinger of things to come. And I had been one of the people who really believed that even though the court took up Dobbs, a patently unconstitutional 15-week ban on abortion in advance of viability, that the Chief Justice at least would be very wary of explicitly overruling Roe a few months before the midterm elections and sending American women to the polls with Roe's death on their lips. But I think what we saw in SB 8 is that maybe the Chief Justice doesn't control this conservative wing anymore. So he was with the liberals, although it should be noted, he did not join Justice Sotomayor's very strident opinion,
Yes.
nor did she join his.
Yes.
So they're definitely, they're together but apart. But he's not with his conservative colleagues either. And so, I think you have to wonder, maybe he has lost control of the conservative wing insofar as this matters. There was talk at the end of last term about how this was really a 3-3-3 court,
Mm-hmm.
3 liberals, 3 in the middle, the chief, Barrett, and Kavanaugh, and then 3 very conservative justices. And I think what we saw in SB 8 was that Barrett and Kavanaugh peeled off to join the really conservative wing of the court. And maybe it's because it's a procedural irregularity, a nothing burger, who knows? But there was definitely a way to sort of put it on ice, and they did not pursue that. And so I think that suggests that they're not inclined to be incremental about Dobbs. And to be clear, Mississippi, in defending this ban on abortion at 15 weeks, has really changed its tune. So when it was requesting certiorari, Mississippi was saying, this is not a big case. We're not asking you to overrule Roe and Casey. We're just asking you to uphold this law. It's really just about moving viability out of the picture a little bit, very limited. That was before September 2020. In September 2020, as we know, Justice Ginsburg passed away. She was replaced by Justice Barrett. Now, Mississippi is filing briefs before the court where they're like, burn it all down, overrule Roe, overrule Casey, let's be legends. And, it's just a very different posture. And I think the only way you can explain it is the change in the court's composition. And I think that is why you are getting this sort of question about the court's legitimacy, because the public may be on TikTok, but they're not blind, right? They're doing other things, but they definitely can see what's before them. And it does feel like all it took to put Roe squarely in the crosshairs was a change in a single seat on the court. And that makes, I think, the court look incredibly politicized, incredibly partisan. The Quinnipiac poll, which has been asking respondents about their views of the court since 2004, just registered the respondents' lowest opinion of the court in the history of that poll. We've seen Justices Thomas, Breyer, and Barrett hit the trail to disclaim the idea that the court is full of partisan hacks, as it were. Should be noted, they really sent the B team out for this because, Justice Barrett said, we are not partisan hacks, while giving a speech at the McConnell Center, flanked by Mitch McConnell. The optics of it could not have been worse. And it felt like she was gaslighting everybody. Justice Thomas, who more than anyone has had a bug in his bonnet about overruling Roe, is talking about the court's legitimacy. He's the one who says that the court doesn't have to defer to precedents it doesn't like. And then Justice Breyer, who's always at great pains to disclaim this idea of the court as partisan, is on the circuit getting these questions because he has a book out, and the book is getting attention because he won't retire.
Right.
So, don't send these 3 out to do this. You need it. Send the chief out, send someone else. But the message is really getting lost. And I think the public is seeing this in really profound ways.
It also strikes me, and, granted, we live in a country where a lot of people don't get good civics lessons and really don't understand our structure and all of that good stuff. But one of the things that I think is so challenging for folks is we can vote for people for Congress. We vote for the president. And the Supreme Court is just this collection of 9 people from, mostly elite law schools. And they get appointed for the rest of their lives, and they just sit there, right? And there's nothing to be done about them. And so, part of that has then started this whole conversation about, well, how do we fix the court, right? Do we pack the court? Do we come up with term limits? All these other sorts of thoughts about what the U.S. Supreme Court should look like. And I'm curious, let me give you a magic wand, right? If you had that magic wand, and you could sort of decide what the right structure is, or what feels like a right structure for the U.S. Supreme Court, what would you do?
I just think it's funny that you said a magic wand, because someone asked my 10-year-old this, and he was like, well, it wouldn't be a wand, it'd be a staff, because I'm a wizard. They were like, okay, fine, it's a staff. So, I don't know what the appropriate structure is. I do think, though, that we are in a situation now where we have always, I think, had some inclination, some inkling that the court really isn't as far removed from politics as they profess. And I think that's becoming incredibly plain. And it's not even that they're not far removed from politics. Now it feels like they're incredibly enmeshed in politics. And I think that is because of abortion. I mean, I think the politicization of the confirmation process, and I've written about this, is really about the abortion question. Like all of these, like the fact that the justices don't say what they're going to do about abortion, won't say, like they defer, they pivot. All of this is because everybody knows that the one question everyone wants to know is, like, how will this new person change the court with regard to this one single precedent? That is really, I think, what has made the court political. And again, I'm not saying this because I know there are anti-choice folks who argue that the reason Roe should be overruled is because it has politicized things. But if it wasn't Roe, it'd be something else. But that it used to be Brown, now it's Roe. That is part of it. And the confirmation process, I think, really makes that clear. But how should we change the court? What should it look like? Everyone has sort of talked about these massive structural changes, many of which would require a constitutional amendment to actually be viable. So, term limits, I think, requires a constitutional amendment. It doesn't require a constitutional amendment to increase the number of people on the court. But as Justice Breyer reminds us, this could be a place of tit for tat.
Yeah.
And you expand the court this way, we expand the court that way. Suddenly the court's 100 different justices. You'll definitely get some diversity in law school representation, because I don't think Yale has 100 people. I think there are other sort of smaller, not quite as cataclysmic interventions that are worth pursuing. Rick Hassan at the University of California, Irvine has talked about stripping the court's jurisdiction over cases that involve voting rights in some respects. Like, that seems quite plausible, and certainly within the realm of Congress's authority. I mean, the other side of this coin is that we not only have a court that appears to be in the throes of politics, we have a Congress that is definitely in the throes of politics and incredibly polarized. So I think part of the frustration that people are experiencing right now is that it doesn't feel like we can do anything, because to do anything requires a kind of bipartisan cooperation or progressives overtaking Congress, which is harder to do now that the congressional districts have been gerrymandered beyond all kinds of proportions. And it just seems ephemeral, this whole idea of being able to do anything in ways that move in a progressive direction. But I think that just underscores how intertwined all of these issues are. So, we are thinking about voting rights and abortion rights and contraception and reproductive rights as these siloed situations, when in fact our fates are linked, right? You don't get a law like SB 8 unless the Texas legislature passes it. And you don't get a Texas legislature that wants to pass an obviously unconstitutional law unless you have redistricted that state to such a degree that you've made it impossible for majority interests to actually be reflected in the composition of the state legislature or in Congress, for that matter. And you don't get that outcome unless you have suppressed those voters who might be willing to take a more progressive view of things. And so voter suppression, redistricting, and gerrymandering, all of this leads inexorably not just to voting rights, but also to all of the other things that we're seeing. And it's about a fundamental question about majoritarian politics, minority rule, and whether we plan to have a democracy.
Yes. And in that sense, it is a very scary time to be living in, because we see, so even with SB 8, so people say, oh, well, there's the Women's Health Protection Act, and that's going to get voted on, and then that'll be really great. And it's like, do you really think that the Senate, even if the House, right, says yes to the Women's Health Protection Act, which they've done, which is meant to codify Roe, which is nice, but still isn't good enough, right? It's never going to actually make it through the Senate. And so we're still going to end up with this incredibly patchy landscape across the country for abortion rights and lots of other things, right? As you say, this isn't just about abortion. It's about how we ruled. It's about who we are as a country in really difficult and painful ways, I think.
I think it's also about the courts. I mean, and this goes beyond the counter-majoritarian theory, but the counter-majoritarian difficulty. It is about harnessing the courts as a means of preserving minority rule. And I think you have the best example of it is what happened with the Affordable Care Act. We all watched as John McCain voted thumbs down on the ACA, wasn't going to repeal it. So instead, they zero out the individual mandate and then take it to court to get a court to do what they cannot do through majoritarian politics. And, the court says no, but it's really interesting. Like, everyone the media talks about how the Supreme Court saved Obamacare. The Supreme Court issued a decision on standing, right? And I think it's likely right that we're not going to see more of the sort of broad challenges to the Affordable Care Act. But I think we are going to see piecemeal challenges to various parts of the Affordable Care Act, certainly the contraceptive mandate. Obamacare isn't an entitlement yet, at least not for everybody. And so, the media is spiking the football when I think, people who are litigating this stuff, like when's the next challenge coming? Because it's certainly coming.
Mm-hmm. So our time is winding down here, but I want to be able to stop on what feels like more of a high note. So I want to talk to you a little bit about Justice Sotomayor, because obviously you clerked for her, and now she sits on the U.S. Supreme Court. Lots of people are sort of talking about her as the person who is, stepping into RBG's shoes now that Justice Ginsburg is gone. But I really think about her as being so distinct from RBG. And yes, she's writing these amazing and these really fiery dissents. But, one of the things that was kind of challenging about RBG, I think for a lot of people, was she was good on some things, right, depending on what your politics are. And maybe if you're, say, Native American, you weren't so impressed by some of the decisions that she was making. And so Justice Sotomayor, I think, is her own creature on the court. But I'm curious what your thoughts are as somebody, who knows her personally, about sort of what her legacy is going to be on this court.
Let me just say, I understand the desire to graft Justice Ginsburg's legacy to someone else, to make an heir, as you would, to Justice Ginsburg. I think Justice Sotomayor stands on her own bottom, right? And I want to make that really clear. She's very distinct from Justice Ginsburg. I think they both have similar sensibilities in terms of women's rights, but I think Justice Sotomayor's brand of feminism, of legal feminism that you see in her opinions, and I think this was most clearly expressed in that FDA versus ACOG decision, is much more intersectional, obviously intersectional, than Justice Ginsburg's was. She was talking, Justice Sotomayor was talking in that ACOG opinion about the degree to which COVID had really impacted communities of color and women of color. And, this is not to say that Justice Ginsburg didn't care about that, but I don't think we saw that in her jurisprudence to the same degree. And, I also don't think you see communities of color reflected in the work of other justices to the same degree. Clarence Thomas, I think, is an exception. And we do see communities of color invoked, although, perhaps not in ways that communities of color are necessarily comfortable with. Although I think in some cases he is actually saying things that a lot of people of color might say, whether you want to assign it to a progressive viewpoint or not. So I think she is her own person, and what she's doing is actually distinct, and it is bringing the voices of women of color to the table in a space where they have not yet been represented. And I think that's going to be hugely important in this latest flap over abortion, because women of color, communities of color really are impacted by abortion regulations, especially in circumstances where they are under-resourced and lack access to medical care, prenatal care, where they have higher rates of maternal and infant mortality. Like, it really impacts them. And I think she is someone to ventilate and surface those concerns. But I also want to point out how crappy the treatment of Justice Sotomayor is by people who write about the court, people who cover the court. And this has persisted, I think, since she was announced as President Obama's nominee. I mean, I remember being a relatively junior law professor and writing to certain members of the press, like, I am absolutely appalled by the way you were talking about her. Like, she's not smart. She's plenty smart. Like, she graduated from Yale Law School. She won the big prize at Princeton, the Pines Prize. Like, you would never say this about someone with the same credentials, C.E.G. Samuel Alito. Every woman of color understands what this feels like to be minimized, regardless of your credentials. Like, there was just this New Yorker article that praised some other podcast over strict scrutiny because the strict scrutiny women are always talking about their credentials. That is not true. But it's also like, what do you expect in a world where there are so few women of color commenting about the court? Of course, we have to establish our bona fides. And of course, she had to establish her bona fides. And, in a lot of cases, it was ignored. And she has done more, I think, than anyone on the currently constituted court to bring the work of the court to the people in terms that people can understand. And that is a kind of demonprudence that we haven't seen in the same way. Justice Ginsburg did a lot of that with some of her dissents, but I mean, Justice Sotomayor is out there pressing the flesh with people and listening to them and making them feel like they know someone on the court. And I think you can't understate that. I think it's really gross when people talk about what she's doing and the dissents that she's right as though this is just laden with emotion. She's writing a fiery dissent. It's, and Justice Kagan, by contrast, is a tactician. She is strategic and she's tactical, and she is. But there is a strategy too to what Justice Sotomayor is doing, because it's go time. This is the time for fiery emotion, and that's a strategy too. And she's speaking to the people, the only people who can actually get between Congress and this court and a dystopia. And if that's not strategy, then you've missed the whole point. All of those folks who are just like underestimating her, it's gross, it's disgusting, and you need to stop.
I remember when she, during the confirmation, when she was getting, peppered with these questions about the speech that she had given about, a wise Latina, and you just sort of knew, right, just from that moment, that she was going to be treated differently on this court, and she'd be treated differently potentially by her colleagues, but certainly by the press, by people in Congress. And I, for one, have just thoroughly enjoyed the role that she's playing on the court. I look forward to her dissents because she's in dissent a lot, but she's really setting a stage that I think is so incredibly important. Well, Melissa, thank you so much. This was a tremendous conversation. It's always wonderful to see you and to talk to you. And maybe we'll be back here in June when we've got a decision.
Thank you for having me. First of all, for your listeners, for your students, it's so amazing to see both you and Dean Cuisinart-Villazor at the helm of Rutgers. I mean, truly, Rutgers, a campus with an amazing Black chancellor, the two of you, two amazing women of color deans. It could not be more profound and more profoundly inspiring for your students. So thank you for all that you're doing. Thank you for this podcast, and thank you for having me.
Absolutely. You're very welcome.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal small campus experience. Learn more by visiting law.rutgers.edu.